Hello everybody, and welcome to the first in our new series of webinars providing an update in relation to property disputes. The first webinar today is going to provide an update in relation to case law about dilapidations. My name is Daniel Bain. I'm an associate in the litigation team here at Shepard and Wedderburn, focusing on property disputes and dilapidations as an area in which I regularly get involved. Now, I've picked two cases from the past year or so to have a look at today, both of which deal with landlords' remedies for dilapidations. The first is Moore Row against DWF, which dealt with damages for breach of repairing obligations, so we'll have a look at that. The other one is Tonsley 2 Trust against Scottish Enterprise, and in looking at that, I'll also recap. Many of you, I'm sure, will be familiar with it already, but I'll recap the appeal court's decision in APSIP against pension trustees, because the decision in Tonsley 2 Trust was very much influenced by that, and APSIP remains a very important case, not just in relation to dilapidations, but also interpretation of commercial contracts generally. Now, I should mention, if anybody has any questions, we should hopefully have some time at the end for one or two questions. So if you do have any, please use the text chat facility to type in your questions, and if we do have time at the end, then hopefully I can pick up one or two of those. So, turning first to Moore Row against DWF. This was a claim for damages for breach of repairing obligations in the lease of office premises at Dalmore House in Glasgow. It was a claim, as many dilapidations claims are, based on the costs of works set out in the schedule of dilapidations issued by the landlord to the tenant. At the time that the court action was raised, the works had not been carried out. Again, that's very often the case with dilapidations claims, but that was very much an issue in this case, which we'll come on to see. Now, as the judge commented in her judgment, a lot of the argument in the case was about the availability or otherwise of landlords' remedies in terms of the lease or at common law, and the judge made some general comments about that, about landlords' remedies in relation to dilapidations in issuing her judgment. She made the point that, of course, when it comes to dilapidations, it's a breach of repairing obligations, and what we're talking about there is are non-pecuniary obligations, non-monetary obligations on the part of the tenant. And in Scotland, generally speaking, the primary remedy for a breach of a non-monetary obligation is an order for specific implement. But in relation to leases, whilst that is a remedy which is available to a landlord during the period of the lease, it is not generally available after the lease has expired, in the absence of express wording in the lease which would entitle a landlord to call upon the tenant to come back to the premises and carry out the works. So, in the absence of express terms to those effects, to that effect, the landlord is left, more often than not, with a common law claim for damages for breach of contract, and the judge in her judgment made some general comments in relation to that. She made the point that in Scotland the courts have long recognised that there might well be more than one means for a landlord to quantify its loss for breach of a tenant's repairing obligation. Very often, as I've mentioned, in fact probably more often than not, the damages are based on the costs of the works which need to be carried out by the landlord, the works which the tenant failed to carry out in terms of the lease. But there are other methods, and diminution in value of the property might well be a method, and as the judge pointed out, the courts in Scotland have long recognised that there may well be more than one method. Also, the judge did make the point that a landlord is entitled to quantify their claim by reference to what it will cost to do the work which the defenders have failed to carry out, circumstances where that is the basis on which they have quantified their claim. Generally speaking, it's not necessary for a landlord to have carried out the works and incurred those costs before making the claim, but that will always depend on the terms of the lease. Having said that, it is open to the tenant to seek to prove that actually the true loss suffered by the landlord is materially less than what has been claimed. That's the general position, as we'll come on to see in Moore Row, the tenant trying to argue on the basis of the lease terms that the works did have to be carried out. Just before we get into that, the judge did also point out, just in relation, in making her general comments about landlord's remedies, pointed out that it's not always the case that a landlord's remedies are confined to those available under the common law, such as specific implement or damages. In some recent cases, the lease has contained a payment clause or a clause for liquidated damages, which has the obvious benefit for a landlord providing a contractual mechanism to obtain payment, often after a simple certification process and without the need to prove the fact or quantification of any actual loss suffered. And in that regard, the judge pointed out the case of ATSIP against ATSIP pension trustees, which we'll come on to look at, and also Tonsley to Trust. But just coming back to Moore Row and the issue in Moore Row, which was, Moore Row didn't involve a payment clause or a liquidated damages clause. It was a claim for damages at common law by the landlord. But the issue, or the main issue in the case, was whether or not the landlord had to have carried out the works before damages could be claimed. And the tenant was arguing here that was the case. Now, there are two key clauses under consideration in the case. The lease contained a clause requiring the tenant to surrender the premises to the landlord in such state and condition as shall in all respects be consistent with full and due performance of the tenant's obligations. And the lease also contained a clause entitling the landlord to enter the premises and examine their state of repair and condition, to give notice requiring the tenant to repair, reinstate and make good defects and wants of repair found in the premises within a reasonable period of time, to carry out such works if the tenant failed to comply with the notice, and to demand payment of all expenses incurred in carrying out such works. Now, you may be thinking, that's all fairly standard stuff, and it certainly appears to me that that's all fairly standard stuff. But the tenant here did attempt to argue that, that the second of those clauses in particular meant that the landlord had to have carried out the works first. The landlord's position was very much reliant on the first of the clauses on the slide there. The landlord argued that the tenant was in breach of that clause, that the tenant had, because there were dilapidations in the premises had not been left in such a state and condition as was consistent with performance of the tenant's obligations. And the landlord's position was that that gave rise to a common law claim for damages. The landlord also argued that the second clause on the slide there was concerned with the position during the period of the lease, and that it didn't apply at lease expiry or after lease expiry. The tenant was very much relying on the second clause there, and the tenant argued that that clause applied both during the lease and after expiry. What the tenant was arguing was that that clause defined the scope of the landlord's rights against the tenant in the event of a default in its obligations of maintenance, repair and reinstatement, whether during the period of the lease or at its expiry. And in particular, what the parties had agreed there, so the tenant argued, was that in the event of such default, the landlord would be entitled to serve a written notice, call upon the tenant to remedy the default within a reasonable period of time as was set out in the notice, and that if the tenant failed to do that, then the landlord would be entitled to carry out the works and claim and demand the cost of doing that. Now, the tenant argued that the clear purpose of that clause was to restrict the tenant's liability only to the cost of such works as were actually carried out in effecting the remedial works, and thus to exclude liability for hypothetical claims in respect of works which have not actually been carried out by the landlord and which might never be carried out. And here it was agreed between the parties that no works had been carried out at the time. Now, the court analysed the clauses in the lease and came to the conclusion that it did not require the landlord to carry out the works before claiming damages, which I suspect will have been a relief to many landlords, and I think would accord with the understanding of anyone who's involved in dilapidations claims, and certainly commercial landlords. As I mentioned earlier, the clauses in question do appear to be fairly standard clauses, and I think if the court had agreed with the tenant's interpretation, I think that would have been a departure from the commonly understood position. The judge did accept the tenant's argument that the second of the clauses, which was on the slide, applied both during the period of the lease and after its expiry. So the landlord, according to the judge, could have relied on the mechanism in that second clause, but because the landlord wasn't relying on that mechanism, hadn't followed that procedure, the landlord was relying on a common law claim for damages based on the failure to hand back the premises in the state of preparing condition which it ought to have been handed back. But while the judge agreed with that, the judge didn't accept that the second of those clauses required that the remedial works had to be undertaken before a case could be made for damages at common law. What the judge said was that nothing in the language of the clause indicated that the procedure it set out was prescriptive rather than permissive of the avenue that the landlord might pursue to remedy the tenant's default of the repairing obligations, or that it required the clause to be interpreted as the landlord foregoing any other remedies that might be available under the common law or restricting them in any way. And what the judge said was that in the absence of clear language that that's what the parties intended, the clause did not preclude a common law claim for damages or first require that the works had to be completed before such a claim could be made. So what do we take from this case? Well, I think the generally understood position prevails. In the absence of express terms to the contrary, a landlord is entitled to quantify its claim for damages by reference to what it will cost to carry out the works which the tenant had failed to carry out, and it's not necessary to have carried out those works before making the claim, but it is open to a tenant to seek to prove that the landlord will suffer no loss, or that the loss will be materially less than the sum claimed by the landlord. And it's a common line of defence by a tenant in circumstances where works haven't been carried out and the landlord's intention is perhaps not clear. Okay, so moving on to look now at payment clauses. And as I mentioned, this kind of relatively recent case here, I think it was around a year ago, it was the Tonsley 2 Trust case. But before coming on to look at that, I think it's worth having a refresher on ATSIP, because the decision in Tonsley was very much influenced by the appeal court decision in ATSIP. ATSIP was the culmination of a number of cases in 2014 and 2015 which dealt with the issue of payment clauses. And it's an important case in relation to that issue, but also more generally in relation to interpretation of commercial contracts and commercial leases. The number of cases which I mentioned started with Grove in May 2014, which was an appeal court decision. Now, that case again dealt not only with the issue of payment clauses for dilapidations, but also more generally with the court's approach to interpretation of contracts, and was very much influenced by the Supreme Court decision from 2011 in a case called Rainy Sky against Cookman Bank. And in that case, the court considered the role to be played by considerations of business common sense in determining what parties meant in the contract. And the court also considered in that case that where the parties have used unambiguous language, the court must apply it. But if there are two possible interpretations, then the court's entitled to prefer the interpretation which is consistent with business common sense and to reject the other. Now, the appeal court in Grove very much followed that approach. That the landlord was trying to argue that the lease in question had a payment clause, and it was all about interpretation of that clause, and the landlord was ultimately unsuccessful in doing that. The court took the view that there were two possible interpretations, but felt that the tenant's interpretation, that it was not a payment clause but rather effectively set out the position at common law, was the interpretation to be preferred. Now, the approach that the appeal court followed in Grove was followed in subsequent cases. It was followed in ATSIP at first instance in September 2014, where again the landlord was unsuccessful in seeking to establish that the lease contained a payment clause. And in Mapley Acquisition against City of Edinburgh Council in March 2015, again the approach in Grove was followed by the judge in rejecting an argument by the landlord that the lease contained a payment clause. Then, in June 2015, we had the Supreme Court judgment in a case called Arnold against Britain, which is, like Rainy Sky, an important judgment regarding interpretation of contracts, particularly on the application of commercial common sense. And what the Supreme Court said in that case about commercial common sense was that commercial common sense in surrounding circumstances should not be invoked to undervalue the importance of the language of the provision, and that commercial common sense is not to be invoked retrospectively, but at the date the contract was made. The fact that a contract has worked out badly for a party is not a reason for departing from the natural language used. The court also commented that the court should be very slow to reject the natural meaning of a provision simply because it appears to be an imprudent term for one of the parties to have agreed. So the effect of Arnold against Britain was to, in effect, set a limit or try to rein in the use of commercial common sense to resolve perceived ambiguities in commercial contracts. And it had a significant effect in December 2015 when the appeal court's decision in ATSIP was issued. Now, the clause that the slide that was just up there has that's the provision in question in ATSIP, and the key wording is the wording in bold there, that the tenant was obliged to pay to the landlord at the determination date a sum equal to the amount required to put the leased subject into good and substantial repair. And as I say, the appeal court, very influenced by the Supreme Court's judgment in Arnold against Britain, overturned the decision of the judge at first instance and concluded that the natural and ordinary meaning of the clause was that it was a payment clause, not a damages clause. The court said that the words clearly indicate that the parties intended that if the subjects were not at termination in the condition in which they would have been if the tenant had complied with its repairing obligations, then the landlord was to be entitled to payment of a sum equal to the cost of bringing them up to that standard. So whether the landlord intended to carry out the works or not was irrelevant. So I'd say that changed the position. The line of cases, Grove, ATSIP at first instance, Mapley, in all of those cases, the courts had rejected a landlord's argument that the leases in question contained a payment clause, and it enabled landlords to more successfully argue that that leases contain payment clauses where there are provisions which are similarly worded. And a case like that came along last year, Tonsley 2 Trust Trustees against Scottish Enterprise. The dilapidations claim under leased premises at Strathclyde Business Park in Bells Hill, and the claim, as in ATSIP, the other payment clause cases I mentioned, was not for damages for breach of the repairing obligations. It was for payment of the total cost of works specified in the schedule of dilapidation on the basis of what the landlord argued was a payment clause. And the clause in question is up on the slide there. Again, the key wording is set out in bold. There's an obligation on the tenant to pay to the landlord in circumstances where the landlord opts for this remedy. There was an obligation on the tenant to pay to the landlord the sum certified by the landlord as being equal to the cost of carrying out such work. in that case, it actually happened to be the same judge deciding Tonsley, the same judge that decided the Mapley case, and it was commented in the case that the wording in the lease was very, very similar to the wording in the lease that was at issue in Mapley. In Mapley, the equivalent wording in bold was the tenant shall pay to the landlord such reasonable sum as shall be certified by the landlord's surveyors as being equal to the cost of carrying out such work. In Mapley, as I've mentioned, the judge rejected the landlord's argument that that was a payment clause, but of course that was before the appeal court's decision in At Sip. And in Tonsley, the same judge was of course bound by the appeal court's decision in At Sip. The judge commented that in light of the appeal court's decision in At Sip and the guidance relating to interpretation of contracts that was provided by the Supreme Court in Arnold against Britain, he didn't think it was open to him to follow the approach that he took in Mapley. And he also said that if at the time of interpreting the clause in Mapley he had the advantage of the guidance provided by the appeal court in At Sip, Supreme Court in Arnold against Britain, then he would have been much less inclined to accept that the tenant's interpretation of the clause was possible, and he thinks it's likely that he would have upheld the landlord's interpretation. So there you can see the effect that the appeal court decision in At Sip was having. So following At Sip, the judge came to the conclusion that the clause was a payment clause, not a damages clause. He said that the ordinary and natural meaning of the clause is that it provides the landlord with the option of certifying a sum equal to the cost of the works necessary to put the premises into the condition in which they ought to have been at the expiry of the lease, had the tenant duly performed its obligations under the lease. So the landlords were entitled to seek payment regardless of whether they intended to carry out the works. Now, there was one other issue which was considered in the Tonsley case, which I think is worth mentioning. There was an argument about certification. Now, you might recall from the earlier slide that the obligation on the tenant was to pay to the landlord the sum certified by the landlord as being equal to the cost of carrying out such works. The landlord's position was that they had certified the sum by giving notification of the claim, in particular by giving notification of the claim in the costed schedule of dilapidations and the cover letter, which presumably demanded payment of the total sum brought out in the schedule. The landlord's position was that the lease didn't require any particular formality for certification, that it could be constituted simply by notifying a claim, and that if it wasn't the schedule of dilapidations, then it was affected by raising the court action, and that on either basis, a reasonable recipient would have been left in no doubt as to the intention of the landlords. The tenant, by contrast, argued that the requirements of certification hadn't been met. Their argument was that certification required a definitive statement, not merely the notification of a claim. And in particular, one of the points that they made was that the schedule of dilapidations and the cover letter couldn't be certification because in terms of the schedule, the landlords had reserved the right to alter and amend it at any time up to full and final settlement of the dilapidations claim. And because in the court action the landlords were relying on the schedule of dilapidations and the letter, then at that point equally applied to the court action. Now the court concluded that the schedule of dilapidations and the cover letter and indeed the court action could constitute certification, but didn't come to a definitive decision on it because the court felt that the issue couldn't be decided without hearing evidence. But some general comments were made about certification, which may be of assistance in a future case involving the issue. 3 points in particular. The court said that what constitutes certifying or a certificate is dependent on the commercial or legal context in which the certification clause appears. Secondly, in general terms, unless the contract provides otherwise, a certificate doesn't need to be in any particular form. Thirdly, it's not necessarily a prerequisite of a certificate that it can be final and conclusive. So, the schedule of dilapidations and the cover letter which accompanied it were, in the opinion of the judge, capable of constituting certification in terms of the payment clause. But as I said, there wasn't a definitive decision on that because the court took the view that evidence would need to be led before a decision could be made. So that was all I was proposing to say about Tonsley. For anyone who actually wants to have a look at the cases, the citations are on the slide there. If anyone does have any questions that they want to ask, now would be the time to type them in. While everyone's thinking about that and thinking if they do have any questions, I just want to plug some future seminars and webinars in this series. Next month we have the latest in our regular breakfast seminars, this time looking at service charge issues. The first one is on 14th of November in Edinburgh, and we're also running it on the 16th of November in Glasgow. There will be a link that you will be sent. There's a link in the slides, in the last slide here, but there's also a link that you'll be sent where you can find more details of that and can sign up. Future webinars in this series, on the 14th of December, we're going to be looking at the new private residential tenancy regime, and in particular on resolving disputes in the new regime. On the 11th of January, we're going to be looking at notices under property contracts such as commercial leases, and in particular how to go about avoiding disputes when serving notices under property contracts. So as I say, details of all of those seminars and webinars can be found on our website, and you can sign up there. The other thing to mention is that if you would like to know more about the payment clause cases that I was talking about earlier on, Grove, ATSIP, Mapley, we produced a webinar on that last year, and that is still available. The recording of that webinar is still available on YouTube and Vimeo, and we'll email you links to that. Also, if you'd like to know more about interpretation of commercial contracts, Arnold against Britain in particular, we also produced a webinar on that last year, which likewise is available on YouTube and Vimeo. Right, that's enough plugging of seminars and webinars for now. Just looking at questions that come through. Now, the question that's come through, these cases concentrate on repairing condition. How would reinstatement of alterations be considered, assuming it might be proved that there would be no loss incurred by such reinstatement works not being carried out? I think in relation to that, the same general principles apply, and in fact, I think in one or possibly both of those cases, there may well have been reinstatement of alterations. I need to look at the details, but the same principles would apply when making a claim for damages for breach of contract. If we're talking about a damages claim, damages for breach of contract, then it is necessary to prove that a loss has been suffered or will be suffered. So where there is a requirement to reinstate alterations, actually, if it can be proved that the landlord has no intention of doing that, or that will be entirely superseded, for example, by refurbishment works that the landlord is going to carry out, then it is open to a tenant to seek to prove that actually, if the works haven't been carried out, then no loss will be suffered. So, as I say, the same general principles apply. But it's also important to bear in mind that if we're talking about a lease as a payment clause, obviously the position is then different. It is open then to the landlord to simply cost the reinstatement works and seek payment. But that is only if the lease entitles the landlord to do that, if there is a payment clause. So it's always important to examine the terms of the lease, the particular lease, the particular provisions, and come to a view on that. And I think one further point that's worth mentioning just in relation to that, the case that I mentioned earlier on, Grove. Now that case has not been overturned. I think significant likelihood that it might have been decided differently had it come after Arnold against Britain, like ATSIP in the appeal court. But it hasn't been overturned, and it still stands. And actually, the tenants' council in Tonsley was very much seeking to rely on the court's approach in Grove in trying to persuade the court that actually the clause in question there was not a payment clause. I personally find it quite difficult to reconcile the two. There are cases and judges who have commented that there are significant differences between the two clauses in Grove and ATSIP. I personally find it quite difficult to reconcile the two, and I suspect that Grove might well have been decided differently if it had followed on from Arnold against Britain. And indeed, the appeal court in ATSIP did say that the guidance, some of the comments that were made by the court in Grove do need to be regarded with some caution following the Supreme Court decision in Arnold against Britain. So I guess just a word of caution in relation to Grove. As I say, it hasn't been overturned. It's still possible to make an argument, depending on the wording of the clause, that it isn't a payment clause. But I think it's just one of these issues that it's always going to be important to take advice. So it's just past 1:30 now. So on that note, probably appropriate that we draw it to a close. If anyone does have any further queries that they have or would like to get in touch, then my contact details are in the slide. We will be following up. We'll send you a link to the recording of the webinar and a link so that you can sign up to seminars and future webinars that I mentioned earlier on. But it just remains for me to say thank you very much for joining me today. I hope it's been useful, and hope you can join me for or join us for our breakfast seminars and future webinars. Thank you very much.